Hello, welcome. My name is José Ferreira Gomes, and I am a professor at the Lisbon Faculty of Law of the University of Lisbon. I welcome you to this contribution to the LP's V-Law review on the topic of attribution of knowledge to companies. This is a topic I've been covering in my research in the last years, and it's a core topic in company law and contracts theory due to its obvious practical importance. Notwithstanding, it has received little attention in many legal systems, despite growing interest in the subject, especially in many case law throughout the world recently. In this research that I've been developing, I've been trying to provide an answer to the following questions. In which situations and on what grounds is it possible to state that a company knows a given fact or circumstance? And given the complexity of the corporate reality, what is the normative or dogmatic criterion for the attribution of knowledge to a company? This is a huge challenge, given the myriad of situations in which attributing knowledge to the company leads to legal effects being produced with judicial or business bases. And it is certainly not possible to cover all these issues in just a few lines. So, as Grigolite notes, there are few problems in civil law that are as basic as knowledge attribution, and that, however, have not yet been resolved in a minimally satisfactory manner. In the same sense, on the other side of the Atlantic in the US, Professor Deborah DeMott explains imputation as being characterized as a disorderly doctrine that is difficult to rationalize and to justify or explain in any satisfying or comprehensive way. So the research I've been developing is just the first foray into the topic in an effort to formulate some solid theoretical criteria that may be useful for legal praxis. And so the idea is that to cover those legal systems where this issue has been developed more in more depth, such as the US, the British, and the German systems, covering case law literature to test several decision-making models and to identify typical cases or groups of cases on which the courts are often asked to express an opinion. And the idea is to have a comparative view of these theoretical traditions that are quite different, yet increasingly more in dialogue with each other, providing common answers to similar problems. So looking first at the German experience, the German case law and literature, what we can see is that there are three basic broad dogmatic stages. So the first one is the theory of absolute knowledge. The second is the theory of knowledge representation. And the third one is the theory of organization risk. So the first, von Gucht's defeat in the codification of the BGB was accompanied by an enthusiastic welcome, mostly from the 1930s on, for the organ theory. Decisions on attributing knowledge to companies were based, as a rule, on an almost logical formal deduction of the idea of organic representation. Hence, the theory of absolute knowledge was born. But as criticisms of von Gucht's organic realism began to intensify, case law embarked on a path of gradual abandonment or relativizing of the absolute knowledge. Knowledge attribution was then redirected to the general frameworks of voluntary representation, and paragraph 166 of the BGB became the core rule of attribution. The theory of knowledge representation was thus born, characterized, above all, by the application of attribution criterion based on the psychological state of those who while not representing the company, could be considered to be a knowledge representative. And lastly, and not without some hesitation, the legal theory and case law redirected knowledge attribution to the theory of organization risk. They see in knowledge, or the lack of it, a risk factor. So the specific organization of each company involves a potential harm to third parties that deal with the company. And these risks can only be controlled and should be borne by the company itself. The US and British experiences, on the other hand, are far more difficult to systematize given the fluid nature of its interpretations and indeed the language used by the courts and literature. That said, it is possible to affirm that the attribution of knowledge to companies is based on development of three fundamental interconnecting pillars. So the first one is the general rules of attribution. The second, the primary rules of attribution. And the third one, the directing mind and will doctrine. So at the base, we have the law of agency. This includes the general rules of attribution, according to which knowledge attribution depends on the specific contractual relationship established between the company, as the principal, and its agent, whether he is an employee, external contractor, or other. It suffices for the purpose for the agent to be vested with authority and for his activity to be relevant for the principal. So despite the oscillations that we shall see later on, members of the corporate bodies, as such, tend not to be classified as agents. Their authority does not depend on a specific contractual bond in an interpretation that has parallels with the continental organism. Attribution of their knowledge to the company obeys to the primary rules of attribution. In the light of the deficiencies in one or other of these possible solutions, a third pillar was developed on which to base attribution. These were the special rules of attribution. These rules intended to resolve specific cases of corporate organizations. At the basis, this is the directing mind and will doctrine, the interpretation of which evolved over time. This is as far as one may systematize in relation to an experience which on both sides of the Atlantic has not always been implemented in the same way. Despite the differences between the continental systems on one hand and the US-British systems on the other one, the grounds for decisions in specific cases are often surprisingly similar. For example, it is possible to establish true dogmatic parallels between the theory of absolute knowledge in the German system and the original version of the directing mind and will doctrine in the US and British systems. The development of the theory in these systems also has many points of contact, even in the closure equating of knowledge attribution to a sometimes unconfessed issue of risk allocation. Across both, the insufficiency of representation as ground for attribution is affirmed. It is a knowledge that such results are only acceptable in extremely simple business organizations. In a somehow recent study, Grigolite reduced civil law grounds for attributing knowledge to three basic issues. So, dissociation between action and knowledge, the lack of transversal set of rules determining a general criterion of attribution, and third, the poor expressiveness of the general criteria of attribution. Contrary to Grigolite's skepticism, I believe that redirecting knowledge attribution to the theory of organization risk, measured by the implementation of the duty of adequate organization, offers a general and appropriate criterion of attribution. Knowledge is attributed to the company not only when the person acting on its behalf knows, but also when, through the fault of organization, that knowledge has not been transmitted to it. In the light of the current state of the art, this seems to be the most satisfactory theoretical orientation, insofar as it offers a framework to explain the attribution phenomenon that is sufficiently solid and coherent when set against the different groups of cases on which the courts have been expressing their opinion. Whether or not knowledge is attributed to the company is therefore a decision of risk allocation. The attribution criteria are, after all, nothing more than normative indicators for assessing to which specific legal sphere the risk of knowledge, or its absence, should be attributed regarding a specific state of affairs. Of course, the explanatory framework we have developed has some fragilities and deficiencies. The wealth of case studies undoubtedly helps to identify these deficiencies and correct them. Even so, at its core, knowledge attribution as allocation of organizational risk is a sufficiently broad dogmatic foundation from which to extract new and better adjusted conclusions. For this reason too, it is right that research that we have been developing throughout years be highlighted by a set of group of cases where implementation of the proposed dogmatic orientation can be tested. In this contribution to the LP's VLR review, we're including just a teaser to the research we've been developing, nothing more than that. And so I would like to highlight, for example, how important this issue is was in recent cases, on a transnational perspective. Let's look, for example, at the scandal that involved Volkswagen, which is also called as the emissions scandal or the Dieselgate. So this has been already analyzed. It's a case that has been analyzed by many courts in different jurisdictions, in different systems. And I'll just give you a small example taken from a decision of the court in Munich in 2016, so you can understand how important this topic is. So imagine X, a person that acquired a car of the Volkswagen make from P. P is the company that sold the car. Having become aware that the information provided on the level of emissions of polluting gases by that vehicle was fraudulent, X sought to rescind the corresponding contract with P, the company that sold the vehicle. P, a vehicle sales company in the Volkswagen group, claimed that the vehicle was produced not by it, but by its parent company, A, and that to that extent, it was not aware that the information provided was fraudulent. The Munich court concluded that since P was 100% owned by A, the knowledge of the latter was attributable to the former. So the daughter company was deemed to know exactly what the mother company knew. Now look at this issue in a transnational perspective. Imagine a consumer in Canada bought a Volkswagen car from Volkswagen Canada. Volkswagen Canada imports the car from Volkswagen US, so it buys the car from a US company, which in turn buys the car from the German distributor from the Volkswagen Group, which in turn buys the car from the company that within the group produces the car. And so we have an issue of attribution of knowledge in the chain within the same group. So can we attribute the knowledge that was in the producing company to the first distributing company that then passes the vehicle to the second distributing company and then to the third, which in turn sells the car to the consumer? And how do we deal with different rules of attribution in Germany, in the US, and Canada? How do we put all this together so that the consumer in Canada can say with a fairly sound grounds that the company in Canada knew or ought to know that the information was fraudulent? So I will give, as I said, this is just a teaser on the research we've been developing that we've published in Portuguese and that will be soon published in English. I still don't know exactly where. But let's start with some basic notions of knowledge and attribution. Let's start by the notion of knowledge. Knowledge is the subjective representation of a certain state of affairs, the intellectual perception of or apprehension of a given reality. Being subjective representation, knowledge is always in a subject, as a result of a specific intellectual operation, the act of knowing. So it's the act of knowing by a specific person. There is no knowledge from a natural point of view without a person, without a subjectum where it occurs. The concept of knowledge may therefore be understood in two different ways: as an act of the subject that knows, when the actual intellectual process of apprehending the reality is at issue, and second, as the object or result of the act of knowing. So knowledge as an object corresponds to a subjective state, to the situation that the subject that knows is in. As an intellectual operation, the act of knowing only exists in man. The subject of the subjective state of knowledge is always a natural person. This is what we may call naturalistic knowledge. And these basic ideas are not entirely valid from a legal point of view. Establishing legal technical concept of knowledge requires consideration of other axiological criteria. Nevertheless, the naturalistic meaning at least serves as a starting point, given that it's not certain that in law we may affirm the existence of a general and unequivocal concept of knowledge. So this is from where we can start, although we can fairly say that we need much more to from a legal point of view, state that someone knows a fact. So, unlike that which is required in a nosological understanding, correspondence between the subjective representation and the reality represented is not part of the notion of knowledge for the purposes of law. In fact, legal systems give effects of false representations, false perceptions of reality, to that which, strictly speaking, is ignorancia. So one only needs to consider the rules on mistake in forming a will. False perception of the reality by the declarant has legal consequences and is taken into account in the process of applying the law. In some cases, where the mistake is relevant, the false perception of reality leads to the transaction being voidable, with the doctrine of will prevailing. In other cases, when the mistake is irrelevant, that mistaken perception does not prevent the typical legal effects of the declaration being produced, which in fact the declarant did not desire. In these cases, there is a protection of reliance that prevails. Likewise, legal systems sometimes associate, sometimes link legal effects with ignorance of the reality. This happens, for example, with the rules on the burden of proof, which, as the legal theory has tended to argue, would imply a legal fiction. So, if a fact has not been proven in court, and it is therefore not recognized by the court creates the fiction that the opposite of it has been proven and bases its decision on such fiction. These rules, they do not solve situations of non-liquid, but determine the court's decision despite doubts concerning the reality of a fact. The result, therefore, is that subjective representation of a given state of affairs, whether true or false, arises as a reality that may be considered by the law and to which the law associates the production of certain effects. This notion of knowledge corresponds precisely to the technical legal meaning that we're dealing with here in this research. So let's now look at the knowledge attribution. Despite the central position of the concept in legal discourse, there is not, strictly speaking, a technical legal notion of attribution. In fact, the plurality of normative possibilities prevents the construction of a single concept. Nevertheless, we can say that attribution corresponds to a normative or a legal effect of allocation. The precise details of that effect depend on the object of the allocation, the place in the system where the normative allocation occurs, and the scope or various scopes at play. So let us see what characterizes the normative allocation that we call knowledge attribution. In the naturalistic sphere, the subjective state of knowledge is always of the person who knows. The act and the object coincide in the same person. The transfer of knowledge, when it exists, operates by means of a new process of intellectual apprehension developed by another person who thus acquires another subjective state of knowledge, different from that of the person that provided him with information to be apprehended. But from a legal point of view, this is not how it happens. For certain purposes, the law dissociates the person that knows from the person to whom the state of knowledge is attributed. Representation of a certain state of affairs as an intellectual process occurs in A, but the person to whom the result of this intellectual operation is attributed is B. A is the subject of the act of knowing, but B, as a result of the normative allocation that we call knowledge attribution, is the subject of the subjective state in question. Knowledge attribution can occur between natural persons. It is sufficient for such purpose for the law to allow dissociation between the subject of the act of knowing and the subject of the subjective state of knowledge. So, in many legal systems, such as, for example, a very well-known paragraph 166 of the BGB in Germany, are based on a phenomenon of attribution. So, the person who knows is the representative, but the knowledge, meaning its legal effects, thanks to the phenomenon of representation, is attributed to the represented party, so to the principal. In the case of legal persons, however, knowledge attribution is the only means of gauging a subjective state of knowledge. In fact, legal persons do not have any psychological substratum in which a representation of a given reality can be found. The act of knowing, by its very nature, is never formed in the legal person. Hence, the legal person's knowledge comes from a dissociation between the legal sphere, where the act of knowing occurs, the natural person, and that to which the knowledge is attributed, the legal person in question. So the criterion or criteria that allows us to conclude attribution are precisely what we are looking for. In which cases can we state that the company knows a specific fact, considering that there is no natural substratum, psychological substratum, where the knowledge occurs. We may add to this another framework, which is becoming increasingly relevant in practice. In certain cases, knowledge attribution can also arise from computer-based acts of knowledge apprehension and knowledge management without any human intervention. In many cases, the processing of information by computer is accompanied by natural persons who absorbed it in that time, thereby forming a given psychological state of knowledge. But in many other cases, I would say in most cases, however, we have attribution of knowledge regardless of any act of knowing by a natural person and of any psychological state. Once again, it is important to define criteria for establishing case-by-case attribution of knowledge to the legal person. This is also covered by the research we've been developing. So if the knowledge exists in a certain computer records, or one or more computer records, one or more servers within the same company or groups of companies, when can we state that the company knows that information? We must therefore note that attributing knowledge to legal persons also has this peculiarity. In some cases, it is the attribution itself that constitutes the attributed knowledge. Let's see. As a rule, knowledge attribution comes from the psychological state of the specific person, and that state may or may not be shared with other persons. But this is not always the case. Sometimes the attributed knowledge does not exist as such in any of the relevant persons. As an object of attribution, it results from the aggregation of several pieces of knowledge. They are fragmented in different persons. So A knows a little bit of the information, B knows a little piece of information, C knows another piece of the information. All these persons work in the same company. And so the idea is that provided, considering the organization risk criteria, that the knowledge that results from the aggregation of these pieces of information from A, B, and C may be attributed to the company. And also this knowledge that is in these pieces of information that are spread out in the organization between A, B, and C may also be complemented by information that is stored in a computer server or in many computer servers throughout the organization. And this can also, we can also make this even more interesting if you consider that all this information can be spread out in distant times and different places. So the absorption of the knowledge of the pieces of information in different persons might not occur at the same time. They might occur in different moments throughout time period, a time frame. Whenever this happens, knowledge attribution is not limited to the allocation of the result of a cognitive process to a person other than the one that knows. In a certain way, it creates the attributed knowledge itself. By aggregating the pieces of information, we are for the first time considering a new information as the aggregate of all those pieces of information that was spread out. One last, albeit introductory observation. In fact, attributing knowledge means attributing legal effects. The law does not attribute the result of an intellectual operation as if it were an object. What the law attributes are the legal effects resulting from that knowledge. The knowledge, when it is not the attribution itself that creates it, is in the person of the intellectual operation. This becomes clear in cases where courts are called on to deal with the duty not to remain ignorant. When the law concludes that a given person did not know but should have known, what it is doing is attributing the legal effects of knowledge, which is ontologically non-existent. So we'll deal with this in this research So this is basically the teaser I would like to share with you in this very first contribution to the LP's V-Law review. Thank you very much for your attention.